So the ATF is facing another major loss in the Texas case challenging the ATF's new rule on frames and receivers. So let's talk about this. How's it going, everyone? My name is Anthony Miranda. I am a licensed and practicing attorney in the state of California with an emphasis on Second Amendment rights. I've been part of Second Amendment litigation both at a state level and a national level while serving as a staff attorney with the Firearms Policy Coalition legal team. My goal with these videos is not to provide any legal advice, but instead to give you insight into the inner workings of Second Amendment litigation and what is currently going on in the Second Amendment battle in this Second Amendment realm. As I mentioned in the intro, in this video we're going to be discussing how the ATF is now facing another major loss in the Texas case challenging the ATF's new rule on frames and receivers. Blackhawk Manufacturing Group, aka 80% Arms, was recently granted the ability to join this case as a new named plaintiff, which the ATF desperately did not want to happen. The ATF did not want 80% Arms to be allowed into this case as a new plaintiff because they knew that the court in this case already granted a preliminary injunction to protect a manufacturer tactical machining and to also protect its customers. The ATF feared that Blackhawk Manufacturing, if added into this case as a new plaintiff, would seek the same type of relief that was granted to tactical machining. And that's exactly what has happened in this case. Blackhawk Manufacturing is now seeking for the court to grant them the same type of preliminary injunction that was granted to tactical machining. The case we're going to be talking about in this video is Vanderstock v. Garland. This lawsuit was filed in the Northern District of Texas against the ATF and their new rule on frames and receivers, which went into effect in August and is currently being enforced by the ATF. In this case, Vanderstock, the plaintiffs, sued the ATF and are seeking for the federal court here in this case to find that the new rule is invalid under the Second Amendment. In this lawsuit, the plaintiffs also requested a preliminary injunction be granted, and essentially that is for the court to enjoin or to temporarily halt the enforcement of the ATF's new rule on frames and receivers while this case is currently going through the process. On review, federal judge Reed O'Connor granted a limited preliminary injunction against the ATF. In reaching his decision, he stated that the ATF's new definition of frame or receiver is facially unlawful. The issue here, he stated, is whether ATF may regulate a component as a frame or receiver even after the ATF determines that the component in question is not a frame or receiver at the time of evaluation. He stated that Congress has not extended the ATF's authority that far, that the firearm part is designed to be or may one day become a frame or receiver does not change the fact that in that moment it is not the frame or receiver of any such weapon. So looking at the ATF's new rule on frames and receivers, this judge found that it is facially invalid under the plain text of the statute and that Congress did not grant the ATF authority to regulate these types of items in this way. So he granted a limited preliminary injunction in favor of one of the plaintiffs, which was Tactical Machining. They are a manufacturer of 80% of parts and kits. Then there was a battle on whether or not the injunction should be expanded, and ultimately the plaintiffs did argue that it should be expanded, to protect the customers of Tactical Machining along with other plaintiffs, and then FPC and its members as well. Judge Reed O'Connor reviewed the arguments and issued his order, granting the expansion of the injunction in part, but also denied it in part. He expanded the injunction to protect the individual named plaintiffs and also the customers of Tactical Machining. However, the court denied the expansion to protect FPC and its members, and also the court denied a national injunction. This meant that Blackhawk Manufacturing, although they were a member of Firearms Policy Coalition, they would not be granted the expansion of the preliminary injunction to protect them against the ATF's actions and would also not protect their customers. Subsequent to that denial, then Blackhawk Manufacturing sought to intervene in this case as a plaintiff. They wanted to become an actual named plaintiff in this case. Well, the court did issue its decision and found that 80% Arms Blackhawk Manufacturing does have an interest in this case, and therefore it granted their motion to intervene. And therefore 80% Arms was granted the ability to join this case as a named plaintiff, which was a huge blow to the ATF. And as soon as 80% Arms was added into this case as a new plaintiff, they have now filed for a motion for preliminary injunction to prevent the ATF from enforcing their new rule on frames and receivers against them as a company and their customers as well. In the motion for preliminary injunction, which 80% Arms just filed, they state that because the final rule, as this court has already determined, is likely to be ultimately found unlawful, and the economic harm caused by the final rule during the pendency of its adjudication would destroy Blackhawk's business, Blackhawk seeks a preliminary injunction to preserve the status quo and thus prevent irreparable harm until the respective rights of the parties can be ascertained. They go on to state that here this court has already found that the claims Blackhawk asserts are likely to prevail on the merits. They then cite to the September 2nd order of the judge and also the later October 1st order, I believe, when he granted the preliminary injunction and also expanded it in favor of the customers of tactical machining. And really, this brief was likely very easy for 80% Arms to file because in this motion for preliminary injunction, it almost wrote itself because they only needed to cite to what the judge already said in his prior order. He already outlined how tactical machining and their interest met all the requirements for a preliminary injunction to be granted. And so here, 80% Arms is just saying we are a similarly situated manufacturer. We have the same issues, the same interests at stake. Our customers have the same interests at stake. And therefore, court, you already ruled in favor of tactical machining, and therefore you should grant it in our favor as well because we are a similar manufacturer. They point out in their motion that they obviously will suffer serious economic harm if the ATF's final rule is not prevented from being enforced against them and their customers. They state, nearly 100% of Blackhawk's business is producing and selling items that are subject to the final rule. Without injunctive relief, Blackhawk will be subject to possible criminal charges if it attempts to provide assembly instructions and or sell parts that the ATF determines violate the final rule, or if it stops selling its parts, it will likely not survive the pendency of this case and will be out of business well before the unlawfulness of the final rule is determined in a final judgment. So here they're saying they really only have two options. If they decide to just ignore what the ATF is saying in their final rule, they are subject to criminal prosecution. Or if they stop selling these items, they will go out of business before this case is resolved. Therefore, they will definitely be very much economically harmed by this final rule that's in place, and therefore the court here should grant the motion for preliminary injunction. They state that for the foregoing reasons, Blackhawk respectfully requests that this court enjoin the enforcement of the final rule as to Blackhawk and its customers and issue a determination that Blackhawk is entitled to the injunctive relief granted in the court's September 2nd and October 1st orders, and remains protected to continue transacting business with its customers to the full extent and capacity as existed prior to the publication of the final rule. So here they're saying, grant the preliminary injunction similar to how you did with tactical machining, preserve the status quo, let us keep doing business like we have prior to this final rule, and also let our customers purchase these items and be protected like they were before this even rule went into effect. So essentially, like we anticipated, they are seeking for the court to expand the prior grants of the preliminary injunction to now also protect them, 80% Arms, and their customers. Now, the ATF will no doubt oppose the expansion of this injunction, but really, I don't know how they're going to win this argument, especially in front of this judge. This judge already granted the preliminary injunction in favor of tactical machining. Here you have a much larger manufacturer of 80% parts and kits, which is 80% Arms, Blackhawk Manufacturing. And so they even have more of an interest in having this rule enjoined. And so it's going to be hard for the ATF to argue against this. I'm curious what they present, but we do know that they will file an opposition because the ATF will oppose any type of action like this. They do not want the injunction to be expanded to also protect this manufacturer and these customers as well. So that's just a quick rundown of what's currently going on in this case, challenging the ATF's new rule on frames and receivers. If you have any questions, go ahead and comment down below and I'll try to answer the best of my ability. You can ask me questions like a few of you on my last video asked me what my favorite EDC gun is, my favorite EDC setup. Now, I know that a lot of you aren't aware, but I have a second channel. I've done a video talking about my EDC setup, so I'll link that down below if you want to watch that video. But my kind of standard go-to EDC firearm is either a Glock 19 with an SRO. Usually I have that kind of in the winter time or just kind of standard time. But if I ever want to go smaller, I will go to a Glock 26. And also I'm going to move towards a Glock 43, which I bought off roster, which cost me an arm and a leg. So if you like this video and support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Al Gore's rhythm. It adds fuel to his jet and signals to YouTube that you guys see value in these videos and in this type of 2A news. Again, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could ever do on my own. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation is built by armed scholars, and this nation will be maintained by armed scholars.